the law, the facts, and the evidence.
Order, members.
Mr. Speaker.
Order. Take your seats, McClap.
Mr. Speaker, honorable members, and Kenyans at large, if I do not talk about my departed relatives, it is because I do not think it is proper to use departed relatives to whip public emotions. It is because I do not think it is proper to use departed relatives to seek public sympathy. And therefore, much as I have also departed relatives, I will not talk about them. Mr. Speaker, before I begin going count by count, allow me also to state on two important questions, and I want honorable members to listen. Two things are important. That this is an historical moment and it is also a constitutional moment because Kenya, under the 2010 Constitution, has never dealt with the impeachment of a deputy president. However, we have dealt in numerous times with the impeachment of governors. And our courts of law have set the threshold on which impeachments should be considered. And I thought from the onset, it is important for me to set out the threshold on which impeachment should be considered, so that as I take you through the evidence that we have, you can gauge the evidence against what the courts of law have decided. Mr. Speaker, allow me to read paragraph 31 of Civil Appeal number 21 of 2014, famously called the Wambora decision. The Wambora decision is now the locus for most of the impeachment cases and has been cited with approval by our Supreme Court. In paragraph 31, the court stated as follows: our reading and interpretation of Article 181 of the Constitution, as read with Section 33 of the County Government Acts, shows that the removal of a governor is the constitutional and political process, underlying constitutional and political process. It is a sui generis process that is quasi-judicial in nature, and rules of natural justice and fair administrative action must be observed. What I'm going to read is the most important part. The impeachment architecture in Article 181 of the Constitution reviews that the removal of a governor is not about criminality or culpability, but is about accountability, is about political governance, as well as policy and political responsibility. Mr. Speaker, the coaching of Article 181 in the Constitution, which relates to removal of a governor, is similar to the coaching of Article 150, which relates to the removal of a deputy governor. And therefore, mutatis mutandis, what the Court of Appeal did state, that the removal of a governor is not about criminal or culpability. It is about accountability, political governance, as well as policy and political responsibility applies to the removal of a deputy president.